Penn Law is a wonderful friend to the center, and we're enormously grateful to their collaboration over many years, especially collaborations that bring scholastic expertise and a scholarship on constitutional issues to the public. On April 9th, Justice of the Supreme Court John Paul Stevens announced his plan to retire from the bench at the close of his term. He is the fourth longest serving justice in the history of the court, and over the past 34 years, he played a very significant role in many important cases, including those involving capital punishment, affirmative action, abortion rights, and executive power. Today, we're joined by a wonderfully distinguished panel of experts and teachers from the University of Pennsylvania Law School for a timely discussion of Stevens' legacy, as well as a discussion of the implications of his retirement. Moderating the conversation and introducing our panelists will be Michael Fitz, the Bernard G. Segal Professor and Dean of Penn Law. Before joining the Penn Law faculty in 1985, Dean Fitz clerked for the late Honorable A. Leon Higginbotham, Jr. of the U.S. Court of Appeals for the Third Circuit. He also served as an attorney advisor in the Office of Legal Counsel at the Department of Justice, where he received a special commendation from the U.S. Attorney General. He's written on questions of administrative law, presidential power, and separation of powers. And as Dean of Penn Law, he's become a leading proponent of integrating legal scholarship with the approaches of other disciplines. It is my pleasure to introduce to you the Dean of Penn Law and a great friend to the National Constitution Center, Dean Michael Fitz.
One of the great joys that I've had at Penn Law School is our partnership with the National Constitution Center, and working with them and the center on a whole variety of different issues, public issues involving constitutional law. We've held joint lectures, we've held panel discussions, conferences. It's a wonderful way in which the Academy can engage with the public at large over some of the most important issues in constitutional interpretation and constitutional law. And David has really been a visionary since he's joined the center, and we look forward to lots of new partnerships in addition to panels like this today. I don't need to tell the people here that this is a very important moment in the constitutional history of the United States. We now have, as David said, Justice Stevens, who is the fourth longest serving justice on the Supreme Court, who has stepped down after really a distinguished period of involved in constitutional matters. We have a new president, who was himself a professor of constitutional law and has a distinct vision both of the government and the court, who will be naming someone who may well be impacting and influencing constitutional interpretation for the next several decades. It's a time when we can really step back and talk about the legacy of Justice Stevens, what impact he's had and in what areas, as well as what the criteria should be and the process should be or will be for the appointment of a new justice, and what that justice's likely impact will be on the court going forward. We have a number of truly distinguished scholars of the Supreme Court who are going to talk about individual areas. But before I just give you a brief introduction of them, I want to set the stage for when Justice Stevens was appointed to the court and Justice Douglas stepped down from the court. To give you a sense, that was 1975. Nobody had ever heard of the internet. The world is flat had a very different meaning in those days. Terrorism was not the issue or the same issue that it is now. We were just coming out of Watergate. And the president, then Justice Ford, nominated a little-known corporate lawyer from the Midwest. And one of the senators who was involved in the confirmation process actually said he wasn't sure whether the nominee was a Democrat or a Republican. There were 3 days of a confirmation hearing, 5 minutes of debate on the floor, and he was confirmed 3 weeks after he was originally nominated by the President of the United States. Needless to say, I'm not sure people are expecting quite the same process this time. But it is interesting to note this process as we now begin to talk about what his legacy has been on the court for the last 35 years. And then think also about what the criterion process should look like now that we're looking at his replacement. So our all-star panel are experts in a sense, the widest range of areas that come before the court. Immediately to my left is Professor Cary Coglianese, who is an expert on the administrative process, the laws relating to the bureaucracy of the United States, and also presidential oversight of the bureaucracy. He's written several books on that topic, numerous articles, and runs the Penn program on regulation. I also should mention he has a JD as well as a PhD in political science, so he may make comments about the confirmation process ultimately as well. Immediately to his left is Professor Seth Kreimer, who is a professor of constitutional law, has written really path-breaking articles about the issues both of civil liberties and the internet and privacy rights. He has also litigated extensively on all of these issues, so he has the perspective both of a scholar and as a litigator as well. To his left is Deborah Pearlstein, who is a faculty fellow at the law school who teaches in international law, international human rights, and international questions of national security. She has extensive practical experience, litigation experience. She was the founding partner of Human Rights First, which oversaw issues involving Guantanamo. She's been extensively involved in issues of international law and human rights. She also, I should mention, clerked for Justice Stevens, and also served as a speechwriter for President Bill Clinton. So she has both an executive and judicial experience. To her left, Professor Kim Roosevelt, who clerked for Justice Souter. He's a constitutional law professor, is co-author of the leading casebook on conflicts of law, as well as the author of a book on constitutional thinking called The Myth of Judicial Activism, which talks about what the criteria by which we should judge decisions by the Supreme Court. He also is the author, for those of you who are into fiction, of In the Shadow of the Law, which is a wonderful novel about working in a law firm. And then to his left, the far left, is Professor Ted Ruger, who is a professor both of constitutional law and legislation. He is a former clerk for Justice Breyer. He has written extensively on questions of the independence of the court and what the determinants are of judicial independence, a question we are all raising at various times in our constitutional history. He's also an expert on how justices change their views over time on the court, and do they, in a sense, adopt different perspectives after years of service than they did when they were originally nominated, a question which has come up many times with respect to a variety of different justices, including Justice Stevens. So the format will be each member of the panel will make sort of a brief presentation, and we will then sort of have a general discussion both about the legacy of Justice Stevens and prospective nominees, and then have the opportunity to open it up for questions from the audience on every topic related to Stevens and his potential successor. And I'm sure you'll hear it here first, who will be nominated by the president in the next few days to the court. In any event, let me turn it over to our first speaker, Cary Coglianese.
Even though we're here sitting in the National Constitution Center, I thought I would start off by saying some remarks about Justice Stevens' contributions outside of the realm of constitutional law. I think my colleagues will spend most of their time on his contributions to constitutional law. One of the reasons that I will do so, outside of the fact that this is an area of great interest to me, I happened to notice a few weeks ago the New York Times published the transcript of an interview that Jeffrey Rosen conducted with Justice Stevens back in the year 2007 in connection with a profile that Rosen wrote for the New York Times Magazine. And in the actual interview transcript, which was published recently, Rosen asks Justice Stevens, "What was your greatest jurisprudential achievement?" And Justice Stevens' first response is rather modest. "Oh, I don't know. I really don't know off the top of my head." But then what he said was striking. He said, "I feel very strongly that I have the correct approach to statutory interpretation." So it's that approach that I would like to talk about, and I'd like to talk about one specific case, the most significant case in modern administrative law that was written by Justice Stevens. The case is called Chevron versus the Natural Resources Defense Council, or NRDC. It was a case decided by the Supreme Court in 1984, and it involved at its core a regulation adopted by the Environmental Protection Agency, or EPA, under the Clean Air Act. Now, the case was known as Chevron versus NRDC because both Chevron sued EPA and the NRDC sued EPA over this regulation, and the suits got combined and it ended up before the Supreme Court, Chevron versus NRDC. The issue involved in that case centered on how to understand one word in the Clean Air Act, the word source. The Clean Air Act gave the EPA authority to regulate sources of air pollution. But what is a source? The EPA regulation defined a source broadly to mean an entire factory or plant or industrial facility. Environmentalists wanted the source to be each individual smokestack at a plant or a factory. But EPA, again, this case rose in 1984, so it was an EPA regulation adopted under the Reagan administration. EPA wanted a more flexible definition of source. They adopted what they called a bubble policy. Imagine a bubble placed over the factory, and as long as the total emissions don't increase out of that bubble, some individual smokestacks can emit more pollution and other smokestacks less. This added flexibility gave the industry a chance to reduce emissions from those smokestacks where it was cheaper to do so and not reduce as much from those other smokestacks where it was more expensive to do so. It aimed to achieve environmental protection while also reducing or at least minimizing the costs. Now, the EPA can only do this if they're acting consistent with the Clean Air Act. That's the statute that governs the agency. And so the question is, does the statute, the word source in that statute, have the kind of flexibility that EPA wanted it to have? Well, when it came to the Supreme Court, Justice Stevens wrote the opinion for a unanimous court, although it was a court of only 6 justices, 3 had recused themselves. And Justice Stevens concluded that if the statute isn't very clear, then the courts are obligated to defer to reasonable interpretations of the terms of a statute by an administrative agency like EPA. And so the court upheld the EPA and its flexible definition of source under the statute. Now, this decision, Chevron versus NRDC, initially didn't seem like all that important. It was just the small decision didn't rank up there with the salience of modern constitutional issues. But it was nevertheless significant in the administrative law context for several reasons. First, it was the way Justice Stevens structured the legal analysis. He articulated a two-step framework that judges to this day apply. The first step, he said, for a court to undertake is to figure out if the statute is clear. If it is, then that clear meaning must apply, and the agency has to follow it, whatever it may think to the contrary. But if the statute isn't clear, then the court is to go to the second step and ask, is the agency's interpretation of the statute reasonable? Not ask whether it's the best interpretation, not ask whether it's the interpretation the judge or judges would give to the statute, but is it reasonable? And if it is, then courts should let the agency go forward. So that framework was important, but there's also another key contribution that this opinion made, and that is when a court gets to that second step, when it is deferring to the agency's interpretation, Chevron holds that the court is obligated to defer to the agency's reasonable interpretation. The court, in a sense, cedes its authority to interpret the statute over to the administrative agency. And a third major contribution that Chevron makes is in the reasoning. Why would that be? Why would the courts, which after all, since Justice Marshall, have taken on the ultimate responsibility, we all suppose, of interpreting what the law is, why would they, in a sense, hand over that authority to the agencies? Well, Justice Stevens wrote that federal judges who have no constituency have a duty to respect legitimate policy choices made by those who do. He pointed out that administrative agencies have a more direct democratic accountability than do judges who have life tenure. Federal judges, after all, serve for life. Administrative agencies ebb and flow and can change, the head of those agencies can change every time a new president comes into power. Justice Stevens' opinion in Chevron versus NRDC, has had an enormous impact in future decisions by the courts. It has articulated the framework that every judge now approaches statutory interpretation when dealing with an administrative agency. And since 1984, lower courts, the Supreme Court, and many, many administrative law scholars have grappled with the meaning of Chevron versus NRDC. To give you an idea of its significance, one can contrast the number of legal citations that courts have given to Chevron versus NRDC versus other major Supreme Court decisions. Roe versus Wade, about 2,000 citations. Marbury versus Madison, about 2,000 citations. Brown v. Board of Education, about 2,000 citations. But Chevron versus NRDC, that opinion written by Justice Stevens in 1984, has garnered over 11,000 citations, over 5 times the amount of citations that some of the most significant, salient, and consequential constitutional law decisions have had. We live in an administrative state. We live in a state in which most law is governed by statutes. And therefore, Justice Stevens, I think, was right in noting that his most significant judicial accomplishment or judicial opinion may well be Chevron versus NRDC.
Thank you, Cary. We'll go back to a more general discussion, but that, of course, gives us a sense of Justice Stevens' impact in administrative law. We will then be moving on to questions of civil liberties.
Well, thanks, Mike. I want to talk a bit about Justice Stevens' legacy in the area of free speech. And I want to come at this in a somewhat roundabout fashion by noting that Justice Stevens began his career and spent the formative first 2 decades of his life as an antitrust lawyer. He came from a practice in which cases were regularly determined by the application of quite general standards, unreasonable restraint of trade and monopolization, to nuances of very complex factual patterns. Coming out of that background, Justice Stevens tended to be skeptical about what he referred to as glittering generalities. He was skeptical that those generalities either could or should decide particular cases. He tended to be less concerned with matters of abstract logic and principle than with the posture of the parties before them and the practical impact of the court's decisions. In the First Amendment area, Justice Stevens retained the antitrust lawyer's sensitivity to industry structure and technological change. He also retained the antitrust lawyer's concern with assuring the preconditions for effective access and competition in what he regarded as the core of the marketplace for ideas. Now, that didn't mean the First Amendment required invalidation of every government intervention in that marketplace. In his first year on the court, 1976, he was confronted in a case called Young versus American Mini Theaters with a Detroit ordinance that required that an adult theater not be located within 1,000 feet of any other adult theater. The ordinance defined adult theater as one used to present material depicting, quote, specified sexual activities. Justice Stevens acknowledged that the theaters were protected by the First Amendment against prosecution, but he concluded the statute had no substantial deterrent effect on access to the materials that were exhibited. You could walk 1,000 feet down the street and see the specified sexual activities. Therefore, Justice Stevens wrote that while the First Amendment won't tolerate the total suppression, as he put it, of erotic materials, it's manifest that society's interest in protecting this type of expression is of a different and lesser magnitude from the interest in untrammeled political debate. He delivered himself the following line: "Few of us would march our sons and daughters off to war to preserve a citizen's right to see specified sexual activities exhibited in the theaters of our choice." Justice Stevens, 2 years later, in a case called FCC against Pacifica Foundation, used similar reasoning to uphold the FCC's requirement that George Carlin's 7 Dirty Word monologue could only be broadcast after 10 p.m., when most children were in bed. Now, on the other hand, in matters where real political dialogue was at stake, Justice Stevens wrote the most aggressive defenses of free speech in a generation. Again, 1982, NAACP against Claiborne Hardware, where he reviewed a decision by the Mississippi Supreme Court that imposed liability on the NAACP and 92 black citizens of the town of Port Gibson, Mississippi. The NAACP and the black community had initiated a group boycott of white merchants as part of an effort during the 1960s to break the grip of segregation and racial subordination. The boycott had not been a well-mannered affair, and the trial court found that Charles Evers, the NAACP field representative, what we would now call a community organizer, began the boycott by informing his audience that they would be watched and that anyone who broke the boycott would, quote, have their necks broken, close quote. The recorded remarks continued: "I don't care how old you are, I don't care how sick you are, I don't care how crazy you are, you better not be caught in these streets shopping in these stores. You needn't go calling the chief of police, he can't help you. He won't offer to sleep in your house." Well, that's somewhat strong and threatening language, but Justice Stevens concluded the First Amendment precluded imposing damages on the boycotters. He reasoned that expression of public issues occupies the highest rung in the hierarchy of the First Amendment values, and the threat of liability would impose a grave threat to the process of self-governance. Here's what he said: "Speech concerning public affairs is more than self-expression, it is the essence of self-government. The emotionally charged rhetoric contained an impassioned plea for black citizens to unify, to support, to respect each other, and to realize their political and economic power. When such appeals do not incite lawless action, they must be regarded as protective speech." Now, even in areas that were not directly political, Justice Stevens retained a very acute concern for the practicalities of the structures that provided access to the marketplace. Shortly after sustaining the NAACP's protection, Justice Stevens single-handedly turned back efforts by Universal City Studios and Disney Corporation to strangle consumer video recording in its cradle. This was 1984, a case called Sony Corporation versus Universal City Studios. And the court reviewed an effort by the movie industry to claim that copyright law prevented Sony from manufacturing and selling video recording devices that could allow consumers to record over-the-air television broadcasts. The movie industry claimed that manufacturing such devices was a means of contributing to the violation of copyright rights held by the movie industry of movies that were broadcast over the air. The papers that Justice Harry Blackmun's made available make it clear that Justice Stevens confronted a court where his colleagues were inclined to go with the movie industry. He single-handedly persuaded the court to have the case re-argued and then brought a majority to agree with his conclusion that as a matter of statutory construction, the movie industry's claim improperly enlarged the scope of the copyright monopoly at the expense of the First Amendment-based policy of providing the fullest possible access to over-the-air communications. Justice Stevens' opinion relied, uniquely to my knowledge, on the testimony of Fred Rogers, who owned the copyright to Mr. Rogers' Neighborhood. Mr. Rogers has testified that he wanted to have his show available as broadly as possible. Justice Stevens quoted him as follows: "My whole approach in broadcasting," says Rogers, "has always been, you are an important person just the way you are." Justice Stevens agreed. He said, if there are millions of owners of video recorders who want to make copies of televised sporting events, religious broadcast events, educational programs like Mr. Rogers' Neighborhoods, and if the proprietors of those programs welcome the practice, then the business of supplying equipment that makes that copying feasible should not be stifled because it's used potentially to infringe on the movie industry's desires. He left open the possibility that Congress could revisit this as a matter of statutory interpretation, but video recording by consumers survived. A decade later, Justice Stevens wrote the opinion for the court in Reno versus ACLU, addressing for the first time the question of whether the internet could claim full First Amendment protection against the Communications Decency Act, which threatened to cripple it. The CDA would have barred the transmission of indecent materials over the internet and required essentially everyone who participated in any internet-related dissemination to engage in self-censorship. It would have, in fact, opened the door to a variety of other limitations that would potentially have crippled the emerging medium. Justice Stevens rejected the claim that this should be treated the way that the FCC treated the 7 dirty words. His comment, neither before or after the enactment of the CDA have the vast democratic fora of the internet been subject to the type of governmental supervision and regulation that applied to the broadcast industry. The internet allows any person with a phone line, he said, to become a town crier with a voice that resonates further than it could from any soapbox. In our cases, provide no basis for qualifying the level of First Amendment scrutiny. Again, Justice Stevens wrote in a way that allowed Congress potentially room to address real problems with more precisely crafted legislation. But he opened the way to allow the establishment of what is now a pillar of our communications regime. It is in large part because of Justice Stevens' opinion in Reno versus ACLU that the internet has flourished in the United States. Now, in recent years, Justice Stevens found himself more often, though not always, in dissent, most prominently recently in the Citizens United campaign finance case regarding corporate political advertising. But whether writing for a majority or for a dissent, Justice Stevens approached the case as a lawyer engaged in the solution of a problem. His analysis focused attention on the challenge of applying considered judgment to case law, to statutes, to real-world consequences. In an era increasingly beset by multi-part tests, high-flown rhetoric, and historical excavation for original intent, Justice Stevens' search for concrete ways to ensure robust and wide-open debate critical to democratic self-governance has been a crucial counterweight.
Deborah Pearlstein.
My area of expertise is national security law in both its constitutional and international law dimensions. And since Justice Stevens announced his intention to retire a few weeks ago, a lot of the sort of reflections in the media have noted that he is the last surviving World War II veteran on the court, and that is certainly true. He enlisted, as he's fond of explaining, the day before Pearl Harbor was attacked, and he has joked that it became immediately apparent how the enemy was going to respond to the news of his enlistment, which is emblematic of Justice Stevens and his wit, I think, in many respects. In any case, it's turned out Justice Stevens was on the court and had occasion to decide probably the most significant set of national security law cases in 50 years, in a generation, since World War II, in many respects. And I've had a lot of questions about, well, to what extent and in what sense did his military service, has his military service played a role in his decisions in these cases? And in particular, people talk about, and I think rightly, two cases. The first is the Justice Stevens majority opinion for the court in the 2004 case of Rasul versus Bush. This was the court's first occasion to opine on the legality of the detentions at Guantanamo Bay. And the question the court faced on that occasion was simply whether or not the court had jurisdiction to hear any of the claims that had been raised, challenging on constitutional law, Geneva Convention, international law grounds, the legality of the program that was being carried out there. And in Rasul, again in 6-3 opinion written by Justice Stevens, the court in a very narrow, lawyerly opinion said, yes, we do have jurisdiction to hear claims from the detainees at Guantanamo Bay. In many respects, the opinion was very modestly written, as I said, lawyerly in its narrowness and in its analysis. But it was really, think back to 2004, the first occasion on which the Supreme Court, and in many respects any court, had said no to the executive branch in its claims for necessity as a result of national security and in particular counterterrorism. So it was an enormously significant decision by the first branch of government. Congress had in fact been silent to this point as well, pushing back against executives' assertion of power. The other decision just 2 years later was a case called Hamdan versus Roosevelt, in which the court concluded that the military commission process established by President George W. Bush, lacked sufficient authorization. Indeed, it lacked any authorization by Congress, and the military commission process itself couldn't continue unless and until the president obtained the necessary authorization from Congress. In both of these cases, and Hamdan maybe even more clearly, Justice Stevens' opinions for the court are significant in many ways, but one of the ways relates very much to what Cary was talking about a few minutes ago, and that is the degree of deference or not the court showed the executive branch. If you imagine that, or if you understand that in many cases in the standard administrative law context, decisions by the EPA, decisions by the FDA, and so forth, the court had some habit, in some respects and for particular reasons, of deferring to executive branch views as long as they are reasonable. You might imagine that the reasons for deferring are even stronger in the national security context, and we can talk about that at some length. But in these cases, remarkably, Justice Stevens showed no deference at all to presidential interpretations of statutes, presidential interpretations of treaties. What was going on here? Well, I think actually two things. And one has to do with sort of his historical background, and the other has to do, I think, with his approach to law on the bench. So 2 minutes of history, which I think is really interesting about Justice Stevens. I think no doubt his wartime experience had some influence, but perhaps even more than that. Immediately following the war, Justice Stevens became a clerk at the Supreme Court himself. He clerked for a not very well-known justice named Wiley Rutledge, just after World War II. And Rutledge had actually been in the majority in the court's decisions, famous decisions, to some extent in Hirabayashi, much more so in Korematsu, a World War II decision, ultimately upholding to some extent the internment of Japanese American citizens in California during the war until 1944. But Rutledge, and in those decisions, Rutledge was very deferential to then President Roosevelt's assertions of military necessity to carry out the internment program, at least the exclusion program. But those decisions didn't sit easily with Justice Rutledge. And indeed, by 1946, when this set of issues came back to the court in the guise of a military commission question, a question in which the court was asked to decide whether it was lawful for the military to try a Japanese general immediately following World War II, a case called In Re Yamashita. And in Yamashita, the majority of the court ended up upholding the military commission trial in that case. But Rutledge dissents, having spent a year or more stewing about his and the impact of his decisions in Korematsu and the other cases. And his dissent is really one of the most eloquent, I think, in Supreme Court history of dissents, certainly in this area, but even if you include Justice Jackson and the others, in saying essentially no. And in particular, he writes about how exigencies, of course, could arise in military necessity, but particularly where the government response imposes a burden on individual rights, it's within the power of the courts to check the reasons for the military response in security matters as anywhere else. Okay, so fast forward 60 years, and Hamdan versus Rumsfeld comes to the court, in which Justice Stevens is not a law clerk, but now a justice on the bench himself, in which the court is asked again to evaluate the legality of military commissions at Guantanamo Bay. And Justice Stevens, as I said, writes for the majority, holding that the president lacked the requisite authorization, even though the president, even sort of under a Chevron standard, had a pretty good argument that congressional authorization for the military commissions already existed. In his opinion in Hamdan, Justice Stevens, among other things, cites and discusses in some series of sentences Rutledge's dissent in Re Yamashita. Not particularly for the proposition that deference is not especially necessary, but at a minimum for the proposition that the court has encountered these questions before and has learned lessons from its past experience. So I think one can make, with not too much difficulty, the historical argument, and Stevens, of course, a great student of Rutledge's relatively brief tenure on the court, that Rutledge and his experience in World War II and his regret to some extent over those cases influenced Stevens' own decision of these cases when they came to him 50 years later. On the other hand, and this is the final set of points I'll make, there is also, in Justice Stevens' jurisprudence, Chevron, right? Typically cited as the quintessential decision arguing in favor of judicial deference to the executive, both on the grounds of the executive's superior political accountability, right? The executive is elected, the justices aren't, and on the grounds that the executive, the president, is in a better position because of his expertise on military matters as commander-in-chief and so forth, to decide great questions of security and military affairs and so forth. How do you square Hamdan on the one hand with Chevron on the others? And maybe Ted will explain to us that this is more about the evolution of Justice Stevens' own thinking on the court. But I guess my own view is that these cases are, in key respects, quite similar and I think evocative of Justice Stevens' view of the role of executive interpretations of law. By the time Chevron came down, the court had long recognized, as Justice Stevens says again in that decision, that executive views can help illuminate statutory meaning when the executive has special expertise on a topic, when it is clear, he wrote in Chevron, that the agency's consideration of the matter had been detailed and reasoned. But it was precisely the lack of such detail and reason in the president's decision to pursue military commissions at Guantanamo Bay, as opposed to existing military justice mechanisms, in particular, courts martial, which had a now 50-year-old, by this time more than 50-year-old history, were well detailed and elaborated in statutory authority passed by Congress. And it was precisely the lack of this reason for deviating from the court-martial process that Justice Stevens found troubling in Hamdan. As he wrote, nothing in the record before us, and looking at the record is something that is sort of classic administrative law, nothing in the record before us demonstrates that it would be impracticable to apply court-martial rules in this case. The only reason offered in support of that determination is the danger posed by international terrorism. Without for one moment underestimating that danger, it is not evident to us why it should require, in the case of Hamdan's trial, any variance from the rules that govern courts martial. Indeed, as the court had learned in briefing for the case, the executive, the political leaders, had largely excluded the JAG lawyers, the military lawyers, with the greatest experience and greatest expertise in anything like a war crimes trial, from the decision-making process that went into choosing military commissions and in designing the commission process themselves. I guess what this leads me to is the conclusion that expertise and record evidence, in Justice Stevens' view, could be enormously valuable, and in that respect, the executive's opinion could be valuable indeed. Far less valuable and far more concerning in the face of the lessons of history was the mere assertion of executive authority because it was the executive asserting it. And we'll see in the cases that inevitably are coming to the court in the next couple of years on these questions whether or not that lesson ends up holding.
Thank you, Deborah. Professor Roosevelt, Kim Roosevelt.
Thank you. Thank you, Dean Fitz, for the introduction. Thank you to the National Constitution Center for hosting this event. Thank you to all of you in the audience for coming here. I will be relatively brief, and you needn't applaud unless you wish to applaud the brevity of my remarks. But I want to take a slightly more speculative tack and ask, what does the Stevens retirement mean for the court in the sense, how are we likely to see changes? So I'll talk very quickly about two issues. The first is national security. And as I think you can tell from Deborah's remarks, Justice Stevens simply is irreplaceable in that sense. He's written some of these very important decisions that Deborah mentioned, and the degree of experience he has, the length of his service, there's simply no way you could find someone else who actually clerked on the court during these World War II era cases and then had the chance as a justice to draw on that experience to write these important decisions. You could not find a replacement for Justice Stevens on national security issues if you wanted to. But I'm not even sure that Obama wants to. So people are talking about, replacing Stevens, and the general line seems to be, well, Stevens is a liberal, Obama's a liberal, the votes won't come out that different, even though, of course, you'll be losing all of this institutional experience and consensus building skill and so on. And at a high level of generality, I think that's probably true. But if you get down to the more specific issues, and if you think about national security specifically, one of the surprising, at least to me, things about the Obama administration has been its continuity with the Bush administration on a lot of the national security issues. So the Obama Department of Justice is making many of the same arguments that the Bush Department of Justice did in terms of its ability to detain people indefinitely without trial at Guantanamo, in terms of the lack of authority of federal judges to order detainees released into the United States. So it may well be that one of the things Obama is looking for in a successor to Justice Stevens is someone who has a more expansive view of executive authority, someone who is not going to be as skeptical as Justice Stevens was, and rightly, I think, of claims of broad executive authority based on necessity and national security. So if you're looking for an area where the court's jurisprudence might change, I think we might see a real shift there. Second, I think another interesting area to think about is the area of gay rights. So one of Justice Stevens' many distinctions is that he's the last remaining member of the court that decided Bowers against Hardwick. Bowers against Hardwick upheld a Georgia criminal ban on sodomy, and it rejected the argument that there was a fundamental right to homosexual conduct. It said, in fact, that this claim is at best facetious. Justice Stevens dissented. Now, if you know a bit about constitutional law, you might think, Bowers, why does that matter? The Supreme Court overruled it. And in fact, it did. In 2003, in Lawrence against Texas, the Supreme Court overruled Bowers, and it endorsed the Stevens dissent. So you might think, what change could there possibly be? Well, there may be a bit of a change because although the Supreme Court's opinion in this Lawrence case, striking down a Texas sodomy ban, said it was endorsing the Stevens dissent in Bowers, it didn't quite adopt exactly everything that Stevens was saying. So in Bowers, in the Stevens dissent, he was saying this kind of intimate conduct falls under the general right to privacy in the same way that decisions about contraception and abortion and child-rearing do. His approach was much more likely to reach the conclusion there is a fundamental right at stake here, which means that the government has to meet a much higher threshold in order to restrict individual liberty. And when the court in Lawrence against Texas struck down the Texas law, reversed Bowers, it didn't say there's a fundamental right here. It didn't say the government has to meet some exceptionally high showing. What it said was Texas has no legitimate interest that justifies this intrusion on the liberty of the individual. So Justice Stevens' replacement is probably not going to be someone who would go this fundamental rights route, who would think in terms of the right to privacy. The court doesn't talk about privacy as much as it used to. For one thing, it tends to talk about liberty more. And so you might wonder, is that going to be a change? Are you going to get a court that's less receptive to claims about gay rights? Well, interestingly, I think the answer to that is probably no. You will get a justice who is different from Stevens, but I think the outcomes will probably not be the same because something else has happened since Bowers. There's been a big shift in public opinion. And many people, even people who are not particularly liberal, are now willing to say there's no legitimate reason for governmental discrimination based on sexual orientation. So I think even though the court is likely to continue using this rational basis standard of review, asking if there is a legitimate reason for differential treatment based on sexual orientation, you will probably still get most discriminatory laws struck down. So this is an example of where a Stevens replacement will not be quite the same. In that sense, the court is going to change, but because society has changed so much in the interim, I think actually the Stevens departure is not going to make a big difference in terms of how the cases come out. Thanks.
Thank you, Kim. And that, he, of course, has begun to focus on the question of what a replacement will mean. But before we take up those and other topics between the panel, Ted Ruger will discuss sort of the general issues about the shift of justices over time, which has been a topic a number of people have discussed with respect to Justice Stevens. Ted.
Thank you. So I'm the last speaker standing between both your questions and our questions about replacement. So let me be brief as well as general. My colleagues have given sort of eloquent descriptions of Justice Stevens' jurisprudence in a number of different very important issue areas. I want to speak more generally about two features of his long tenure on the court, ideology and methodology. First, as to ideology, we have this often noted paradox with Justice Stevens that you have a Republican appointee, appointed by Gerald Ford, who became, by the end of his tenure, the most reliable liberal vote, and indeed the most frequent dissenter, and occasionally the lone dissenter in various cases. And this leads to the debate, well, which Justice Stevens himself poses and takes a position on. Did Justice Stevens change in his 35 years, or did the court? And of course, he's on record as saying he didn't change, the court did. So which is it, the court or Justice Stevens? Having thought about this quite a bit myself, and having looked at a lot of kind of rigorous empirical studies that political scientists have done on this question, the fact is both claims are right, over the past 35 years. The court has moved to the right. But it's also quite clear from kind of looking at thousands of votes that Justice Stevens cast over 35 years that his voting behavior did trend more liberal in the last 15 to 20 years of his long career than it did in the first decade he was on the court. And I'll say a bit more about the measures used, but I think it's clear that Justice Stevens' revealed voting behavior did change while he was on the court. I'll talk about a couple measures political scientists use. First, apropos of the current season, when we soon will have a new appointee, political scientists like to study the kind of perceptions of the nominee at the time he or she is up for the court. So this is, there's a metric known as the Segal cover score, which we have data on now going back several decades, which is just an aggregate of what, in a sense, the chattering classes, the media, et cetera, measured by newspaper editorials. Today, these measures build in blogs and things like that, are saying about the relative liberalism or conservatism or moderation in between of the nominee. So this is before they ever serve on the court. So it's only a prediction and therefore sometimes a very weak predictor. And for Stevens, interestingly, he was viewed as very conservative at the time he was nominated by President Ford in 1975. Of the justices who've served in the past few decades, only Scalia, Thomas, and Alito graded out as more conservative, as predicted by newspaper editorials of the time. In other words, Kennedy, O'Connor, Roberts, all of them were predicted to be more moderate than Stevens, judged at the time of his appointment. Now, we know that was wrong, and that was probably wrong even at the time. Even by 1976, that was probably erroneous. It was probably perhaps generated by a misleading sense that this was a corporate lawyer from the Midwest, which used to be associated, I think, with kind of core Republican principles. And so that measure was probably off from the beginning. So I think the better measure and the more sophisticated one is a newer one that some political scientists that I've worked with have developed that measures justices' actual votes in relation to other justices on the court with them and even longitudinally across time. This is called the Martin-Quinn score, developed by Andrew Martin and Kevin Quinn. And it's able to track a justice's voting behavior over his or her career. And there what we do see a trend in the liberal direction for Justice Stevens, starting in about the early 80s and picking up pace in the late 80s and early 90s. And so in the first, say, 5 years he was on the court, Justice Stevens tended to vote with conservatives like Justice Rehnquist and Chief Justice Berger. Most notably, and in a pair of cases that I think illustrates a shift in at least one area, in the famous 1976, or late 1970s affirmative action case of Bakke versus the University of California, Justice Stevens was one of the 4 justices who would have voted to strike down a quota-based affirmative action program in a public medical school on the rationale that race is never, ever permissible to be taken into account by admissions officers under the Equal Protection Clause at a public university. Now that same issue came up, of course, just a few years ago in the University of Michigan cases when the Michigan Law School had implemented a different program that didn't include quotas or rigid numerical formulas, but did permit individualistic, non-quantitative consideration of racial background. And this plan was upheld by a slim 5-4 vote, with Justice Stevens joining that group of 5 and thus providing a key vote. So at least on that issue, he seems to have moved somewhat. Does this mean it was a change in ideology? It may be on at least a few issues, and it may be that over a long 35-year period, like many people, his views changed somewhat. It may also have been an interaction with other members on the court. And here, his claim that the court moved to the right has a more specific, may well have had a more specific reason for his late career voting behavior. What we see if we examine all of his votes is his turn to the left, if you will, his turn to a relatively more liberal style of voting became particularly noted in the years when Justices Brennan, Marshall, and Blackmun retired. So in other words, after those 3 left, you see Justice Stevens voting in a more liberal direction more often, or if you're uncomfortable, as many are with good reason, with the blunt terms liberal and conservatives, you could say after Brennan, Marshall, and Blackmun left, Justice Stevens became less likely to vote together with Scalia and Thomas. In other words, for the past 15 years, he's been the least likely across a whole term or across a whole decade to vote together with Thomas. And that behavior increased when the famous liberals, Brennan, Marshall, and Blackmun, retired. So there may be something more than mere attitudes or preferences here, and this fits with other theories of institutional judicial behavior. It may be that Justice Stevens felt, without his former brethren to express views he thought were important, that there was some role of dissent for dissent's sake or deliberation for deliberation's sake on the court, which is perhaps different than a pure attitudinal theory. So let me leave the ideology questions there, and I'm happy to discuss more. To speak about something which I think is quite different and only weakly interacts with ideology, let me speak about methodology. And I think what we are losing when we lose Justice Stevens is a kind of master craftsman in a remarkably eclectic range of interpretive methods. One thing that happens every time we're seeking a new justice is we hear these adjectives thrown around, where we want a textual judge, or a living constitutionalist judge, or a strict constructionist judge. When I teach students in a statutory interpretation class, I call these the foundationalist theories of statutory interpretation, that it's all about the text, or it's all about an eclectic kind of dynamic view of the changing circumstances. And there are a few judges on the federal bench that exhibit that kind of pure, parsimonious construction. Most notably, ironically, given that Justice Stevens is Chicago native, two judges in Chicago. Frank Easterbrook is, I think, the closest thing to a pure textualist we have, and his Seventh Circuit colleague, Richard Posner, is the closest thing we have to a pure consequentialist judge. He cares about the optimal incentives and results and very little about the traditional legal materials, whereas Easterbrook thinks it's all about the words on the page and nothing else. We have some exemplars, some kind of folks in affinity with those two on the Supreme Court, and I would identify Scalia and Thomas in kind of the textualist originalist camp, and probably Justice Breyer in the kind of Posnerian, kind of rational consequentialist camp. When I teach Justice Stevens' opinion, what's remarkable is he's kind of multilingual across those different methodologies. He can give and take with Scalia on pure textual analysis or originalism, and I think, for instance, of his primary dissent in the Heller case, the gun case coming out of the District of Columbia last year. Stevens joined the battle with Scalia on the deep history of the Second Amendment and produced an opinion that many historians think is a better description of attitudes about the Second Amendment circa 1789. Whereas Breyer in dissent didn't join with Scalia at all. He went off in a different direction methodology. So Stevens, likewise in the statutory interpretation context, there's a wonderful case I teach about the Endangered Species Act, where Stevens and Scalia square off again, this time Stevens in the majority. It's called Sweet Home versus Babbitt, about the scope of the Endangered Species Act over farming activities. And the Stevens opinion is a tour de force of multiple methodologies: textualism, legislative history, institutional interaction, etc. So he's, I think, a typical judge on American courts today in his eclectic use of multiple methodologies. He's just much better at deploying the vernaculars of these different methodologies than most of his colleagues on the court or in the lower federal bench, and he will be certainly missed on that score.
I want to sort of raise a couple other issues about Justice Stevens that haven't been spoken of as much, which is his relationship with the other justices. That is, we frequently hear discussions about the ability of a justice to create a consensus, to bring other justices along, to convince other justices, or to write opinions that will, over time, bring justices to their views. To what extent was Justice Stevens effective in that role during his period on the court, in a sense, bringing others to the court to his views?
When he was in the majority, he was responsible for assigning who on the court was going to write the opinion. and he had the regular practice, and this isn't necessarily rocket science, but it's nonetheless good strategy, of often assigning the opinion to the justice in his majority he thought was perhaps most wavering. So you can see when Stevens was in the majority, the more conservative members of the court in the minority, Stevens assigning opinions to O'Connor, Stevens assigning opinions to Kennedy, the swing justice, to make sure that they could craft, at least in the first instance, a decision that they were most likely to hold together. So I think, no question, he certainly played that role. I also think that one can overstate the importance of his role as consensus builder. As Ted pointed out, there are a number of decisions throughout his tenure on the court up until very recently in which you see 8-to-1 votes in which Stevens is the one. And I had occasion to work on one of them when I was a clerk. And he approached that case the same way he approached every case, which is to say, what is actually going on here? What are the facts? The first thing he did with every case was master the facts, the record below, the lower court decisions, and write them out for himself so he knew he had sort of mastered it. And then proceed through a very sort of highly technical legal analysis, whether statutory interpretation, constitutional interpretation, that was leavened with a lot of his own views of the role of the judge until he came to what he believed had to be the right decision. And if the decision he believed was right was the one he was alone on, or if it was one that ultimately led him not to persuade the fifth to join a majority, once he persuaded himself, he was always persuadable. You could make an argument, and if it was a good one, he'd hear it. But once he came to a conclusion, that trumped, from my point of view, the absolute necessity of consensus above all, at least in many cases.
A lot of people have spoken at length about the qualities that the successor to Justice Stevens should have. Somebody with empathy, and President Obama said on a previous occasion, he described Justice Stevens as an impartial guardian of the law. We all have our sort of broad standards by which we think the next justice should be selected and then reviewed and advised and consent by the Senate. But it does raise the question, are there things the president should be looking for in the next justice? Are there qualities that are important? We all have to be very humble about this when we think back to Justice Stevens' own confirmation, when nobody had any idea what issues he would face over the next 35 years. But are there specific things that a president should look for in a potential justice? For example, some people have said we need somebody with political experience. President Clinton has said the next justice on the Supreme Court should be somebody from politics. Everybody seems to say that, but then we seem to be nominating people who have extensive periods of time in courts of appeals. Is political experience an important criteria? Are we likely to see somebody from politics rather than the court? And before you answer, you should know this probably will be seen after we know who the nominee is, so you should speak with some circumspection. What about political experience or another criteria?
The theme of my remarks was that Justice Stevens came with the worldview of someone who had practiced law. And the importance of the facts, the importance of the implications on the ground of the decisions he made seemed to loom large in the way he approached cases. At this point, other than Justice Sotomayor, I can't think of anyone else on the court who has been at least a practicing lawyer. It seems to me that if one loses that perspective, even if one can't get someone with political wisdom, the minimum Justice Stevens' successor should have is someone who brings the capacity to look at the cases before them as someone who has been in the trenches dealing with the way that the system works. I mean, I didn't talk about it, but one of Justice Stevens' legacies actually turns out to be a very robust set of cases providing practical remedies for people who have had their constitutional rights violated in very technical ways that I won't go into. But it seems to me that follows from his sense of the importance of the real ground level import of the cases he decides. And I would hope that a successor would bring that to the table.
So law professors are out.
I would say
Lawyers
we have a surfeit of law professors on the Supreme Court. I say this without any adverse effect on my probability of being appointed, since I am clearly not at the front of the line.
I mean, the question about political background hasn't been directly addressed. You know, everyone talks about when Chief Justice Warren was able, perhaps because of his political background, to shape the interactions on the court. Is there any reason to believe that somebody with political experience would be a better nominee to the court, all things being equal?
I do think diversity of experience is really essential to have on the court, and to have a court that's composed of people whose working lives have been spent primarily on the federal courts of appeal is a very bad thing. Because the primary thing that the court has to decide, I think, this is sort of my approach to constitutional decision making, but the primary thing the court has to decide is how much it trusts the other governmental actor whose conduct it's reviewing. So how much does it trust a state legislature or Congress or the president in a particular area to make a particular decision? And it's immensely, immensely valuable, I think, to have people on the court who have actually been there making those decisions. So they can say, you know, oh, I was in Congress, and, you know, we really do think about federalism values when we pass these laws. Or, you know, we really do look for a real effect on interstate commerce. I mean, neither of those things is true. But if you had someone there who could say that sort of thing and tell the justices on the basis of experience, you know, yes, this state legislature takes its constitutional responsibilities seriously and you can trust it, or alternatively, no, it doesn't. That, I think, would really help the Supreme Court decision-making process.
Suppose each of you could know one thing about a potential nominee to the court. You were White House counsel or the president. What would it be?
It seems to me a version of asking sort of what you've been asking, which is what are the criteria that are most valuable. And I have to say, I'm not of the school that it would be great to have more politicians on the court, both because I think their ability kind of as a group to forge consensus or not is likely overstated. That has much more to do, as Kim said, with temperament than with particular vocation at any given time. So you could have a non-consensus building politician and a great consensus building, law professor. But I do think, I guess along those lines, I think legal background, a facility with the law, fluency in the law, whether it comes from judicial experience, which I think would be great, actually, because it combines practical experience with a real sort of overview of legal issues and mastery necessarily of the field. You know, I guess I think finding somebody who has that kind of facility with the law is most important. My own view is the more the court is seen to be political or politicized, as I think it inevitably would be if we started appointing politicians to the court, the more its legitimacy generally comes into question, and the more sort of we may lose the relative autonomy of the law. That's sort of the reason people have thought judicial review, independent judicial review, can be important. So,
well, that, of course, raises the question about the confirmation process itself. Is it broken? Are there problems with it in terms of the, quote, politicization of it? And if it is there any way to change it in any systematic way?
The framers consciously put the choice of Supreme Court justices and all Article III judges in the political process, and they consciously put it in two branches, both the White House and the Senate. And they did so for good reason. As Justice Stevens himself said in Chevron, once life-tenured judges are appointed, there's no political accountability, so we ought to have some upfront political accountability. So I don't think it's problematic that we have political debates over who our judges are. However, those debates play out in the halls and chambers of Congress, where As many have noted across many topics in the past few years or even few decades, debate seems to be more partisan, more rancorous, and it's filtered in the Senate through this filibuster device, which allows a minority of senators in one party to block the majority both in the Senate and in the White House. So those are the general problems. I think perhaps differ from some of my colleagues. I don't think there's a special problem with the nomination process.
I tend to agree with Ted in terms of the polarization over the nomination process being a special case of the broader polarization. It does seem to me, though, that if you compare contemporary Supreme Court nominations to Supreme Court nominations 2 generations ago, that one of the things that has differed is that the tenure in office is much longer over the past generation. So that during the first 150 to 180 years of the Supreme Court, you had an average tenure in office of between 12 and 14 years. Over the last generation, it's gone up to about 26 years. So that the magnitude and irrevocability of the decision is greater, and the ability of the political process to provide correction down the line is less. With more stakes on the table, there's more concentration from both interest groups and partisans within the process. So, and again, without a constitutional amendment, I'm not sure we can do anything about that. But it does seem to me there is a structural issue here.
Questions from the audience?
I see 2 pathways for equilibrium. One is through what we're talking about now, and that's a replacement. But someone who has the experience of this justice also has had tremendous impact on his colleagues. So egos aside, is there someone or a group that you will see will possibly act a little bit differently in his leaving? And that is something that possibly would work toward a new equilibrium.
One thing we haven't talked about is the areas in which Justice Stevens has held down a unique position that may well have changed the equilibrium of the court. He, I think, is probably the most committed justice to the idea of separation of church and state, the wall between church and state, the importance of eliminating improper influence by religious bodies over public policy. My suspicion is that with his commitment leaving, unless he is replaced by someone equally committed, you may well get a different equilibrium out of the court.
I guess I might cite the death penalty cases. This is one of the areas, I'm generally of the view that the court moved farther than Justice Stevens moved in terms of its views over the last 30 years. But I would cite 2 areas. One is affirmative action, and the other is on questions of the death penalty, where Justice Stevens' own views evolved to some extent. He was never what I would have called a death penalty hawk, but always very conscious of it. And when Marshall and Brennan left the court, they had been in the habit of dissenting with respect to every death penalty decision on the grounds that they thought the death penalty itself was unconstitutional. Justice Stevens didn't, when they left, move to fill that role precisely, but he did move to fill that role in some respects, dissenting, for example, when the court didn't allow adequate time for the lower courts to get through their process of habeas and reviewing death cases and so forth. But very close to the end of his tenure, what is now the end of his tenure, his views on the death penalty hardened, which is to say, after watching the system in operation for 30 years, it seems clear to me that we are incapable of doing this in a way that's fair and therefore constitutional. And, you know, who will step in to fill even that much more modest role, even though Justice Stevens then went and voted consistent with precedent because he didn't feel it was the court's proper role to overturn cases unnecessarily. It'll be interesting to see who, if anybody, moves to fill the left on questions of the death penalty. You see the left moving nature, I think, even of folks like Justice Breyer over their relatively brief tenures on the court so far. So I'll be interested to see if Breyer and maybe Sotomayor moves in to fill that gap.
Next question. Yes.
My question is for Mrs. Pearlstein. You were so descriptive in your in Justice Stephen and his judgment for the Hamdan case. If I understood you correctly, you said you were describing how Justice Stephen went out of his profile in his view for the Hamdan case. Now, my question is to you, your opinion, your personal opinion as an honorable free citizen, as an insider, as a privileged informant for that case, what do you think of the Hamdan case? Do you think? Your opinion.
I guess two additional points maybe I should make. First is what I hope to be arguing, or was trying to argue, is that while one might be tempted to view Hamdan as surprisingly undeferential for Justice Stevens in light of Chevron in particular, in fact, I would argue it's much more consistent with his general attention to the record, the facts, the reasons why one might want the court to defer. In other words, if somebody has genuine expertise on something, he thinks the courts may have a lot to learn from that. If, on the other hand, there's no evidence of particular expertise, either because there's no record at all, or there are no reasons at all, or because the people who were actually expert on the questions before the court were excluded from decision-making, then the reasons for deference may become much less salient. I would like to say, the second thing I'll say is, I would like to say, when we were asked about what great decisions will be his legacy, I would like to say Hamdan is one of them for its absolute insistence during what many consider wartime on the importance of independent judicial review. I hope that will be the case. My fear, however, is that Kim may be right. Hamdan itself was decided 5-3. There were only 8 justices voting because now Chief Justice Roberts had just joined the court. He was on the lower court at the time Hamdan was decided, and he had decided the other way, that is, in favor of the president. So he recused himself once he was on the court from reviewing essentially his own opinion. If you added Roberts' vote in, it would be a 5-4 opinion. And you can't replace Justice Stevens in many respects, but particularly on these questions of executive power, the traditional sort of left-right conservative liberal divides don't necessarily tell you a whole lot. And my fear is that it may end up being a more fragile decision than, in my view, it should be.
One more question.
Okay, President Obama has intimated that he's looking for a candidate who has a sense of perhaps sensitivity and caring for our fellow citizens, perhaps based upon his or her non-legal experience. My question is twofold. Should that be something that President Obama should really be considering, that is sensitivity? And 2, do they teach sensitivity at Penn Law School?
When you talk about non-legal background, that can mean a lot of things. And let me take an answer that encompasses 2 centuries and actually does implicate Justice Stevens' retirement in a couple ways. The notion that judges, the 9 justices, or originally 7, but the 9 justices on the Supreme Court would reflect the diversity of the U.S. or kind of be a mixture of people is of long standing. For the first century, it manifested mainly as geographic representativeness. So Justice Stevens is the only Midwesterner on the court. I happen to be a Midwesterner, so I'm moderately sensitive to this. If he retires and is not replaced by a Midwesterner, it would have been unthinkable 150 years ago that, that he would not be replaced by somebody from the upper Midwest. Of course, now very few people are talking about that, and even I don't think that's terribly important. Other background characteristics have become more important, and my general point would be that I think it's entirely appropriate to think about the court and America and the way that the court reflects America, and people have been doing that for 2 centuries, even as the criteria have changed somewhat.
I think this has been literally a workshop in issues of constitutional law from almost every perspective. We started out talking about a career of somebody that spans 35 years. And as you could tell, every single area of Supreme Court jurisprudence has, Justice Stevens has been a figure in. And we've seen how the importance he's had in so many areas of the law, his particular approach to the Supreme Court, and how it differs from that of many of the other justices, his personality and the ways in which it did or did not influence his brethren on the court. But given all of that, it then obviously leads to the question of what his legacy will be going back over 35 years. And I think you've seen a discussion of almost every aspect of the man and what a great justice he was in so many different areas, but also a sense of the humility at which we're looking forward about how we would choose another justice of the Supreme Court, and even if we knew the appropriate criteria, whether or not in the end we would be very predictive. In any event, I really do want to thank this panel. It's been marvelous. Professors Cary Coglianese, Seth Kreimer, Deborah Pearlstein, Kim Roosevelt, and Ted Ruger. I think they all did a marvelous job, and I want to thank them. And I also want to thank the National Constitution Center, which really understands the importance of connecting the Constitution to the American public, which it is the American public's document. Thank you all.